I'm just going to do my summation. I really am. We appreciate Mr. Fallon's statements and his willingness to reach a compromise and remove his objection. We heard a lot here tonight about the tower in the public comment section, which obviously is not evidence. Truth of the matter is we have an ordinance we have to deal with, and both federal and state law we have to deal with, and we presented all of that evidence as required. And that was confirmed not just by us, but by the county's own consultant, who looked at the evidence and said we met the requirements for the issuance of a special use permit for the tower. That was really clear in terms of the consultant. No wavering, no nothing. The consultant was really upfront on that. That's not somebody we asked. That's the county had hired that person to do that. I know there was a lot said tonight about health and safety. I just feel like I need to say something just to clarify that. It's very clear under section 160D-932 of the general statutes that in considering a special use permit, radio frequency from towers is not to be considered by the board. That is clear, unequivocal from the general statutes. And that's just for a variety of reasons. It's well regulated. And the signs that are on the site are for that regulation. That's what those regulations require, that when you enter the site, it's a different standard. It's not a public standard. It's an occupational standard. And so it's letting the folks know that work on that tower, or the public know that you're not supposed to come in here because you're not qualified to be in the presence of the tower and to deal with the equipment that's there. That's exactly what that means. But as far as your decision, it's based upon the fact that the state law says that is irrelevant. So I just wanted to make that clear. A lot was made of standing, and I do want to briefly speak to that. Standing, you have to show specific damages, special damages as it's called under the statute. And there's some cases that deal with it, and one in particular I think does a very good thing in terms of defining what standing is. This is a case in Raleigh in a historic neighborhood where there was a modernistic house somebody wanted to build, and the rest of the neighbors didn't like it. And the neighbor across the street didn't like it. Said, I just don't want to sit on my front porch and look at that house because I don't think it fits in the neighborhood. Well, the Court of Appeals took a look at that and said very clearly, because you don't like the way it looks is not enough to grant you standing. That doesn't give you the opportunity to object to it, and that's not a sufficient basis to do that, and that's not special damages. And that's a lot of what was stated here. We don't want to look at it. Well, this lady in Raleigh didn't want to look at that house, but the court said that is not sufficient. That's not enough evidence to show that there's special damages. And there's been nothing presented even before. And again, I appreciate Mr. Fallon withdrawing his opposition, but nothing was presented. He did not present anything specific to show special damages as a result. So just a combination of everything. Our packet that was introduced into evidence, the confirmation by the county's own consultant, the law, as I just read from the case of Cherry versus Weisner in Raleigh, that very specifically said just because you don't like the way it looks is not enough. Then I ask you to approve the special use permit because in this instance you've got standards to follow. A rezoning you don't. A rezoning is particularly discretionary to a large degree and a political decision, but a special use permit is not. If we meet the standards, you're compelled to grant it. In this case, we met the standards. Nothing has been presented that was material and substantial in opposition to that. Therefore, the permit has to be granted. I'm happy to answer any questions you may have. I have our appraiser and George Davis from the applicant. I do want to let you know as well, even though Verizon's the applicant here, your ordinance very clearly makes this tower available, and Mr. Davis wants the tower available to any of the carriers. Your ordinance requires that additional carriers be allowed, and that that if you need it for county emergency services, that it's made available, and that's all a condition of the permit. So I did want to make that clarification as well. So even though Verizon has taken the first step here, they're not the only one. This is not just for them. And so, any questions? If not, I just ask that you follow the requirements under the law and grant the special use permit.
I have a couple of questions. Are there any requirements for a timeline of getting equipment on this tower? I've seen towers set up for 10, 12, 15 years with nothing on them. And, to me, that's certainly an injustice, having to look at a tower that provides nothing.
Right.
If you could answer that, then I would.
As I understand your ordinance, you have to have a carrier, so your ordinance provides for that. But also, I will tell you, Mr. Davis is not gonna build this tower and not have somebody on there that is gonna be paying rent on that tower. It's just like building a vacant building. I mean, Mr. Davis, but,
You want me to?
well, but just, it's not gonna be built without somebody on it. And that's not gonna happen. Now, there may be now, I will warn you, just like anybody else, that they have a building, they build, and they've got tenants, and the tenants have to do upfit. There will be some time for the carriers to be able to do their upfit, because they've got to get a separate co-location permit, and there are other permits to be able to install on the tower. So the tower has to be completed, but there is a time period where you may not see anybody on there, but that doesn't mean they're not going on there. It takes them a time to ramp up and get on there. Well, okay, and George didn't want to speak to it, but you have to be sworn, and I guess you'd be sworn again, or, yeah.
Are,